Hello, hi, and welcome. This session is about articles of association, and in this topic, we are going to learn the definition of articles of association, and apart from that, we also discuss various provisions under articles of association. So, dear students, you know that section 2 subsection 5 of Companies Act 2013 says articles means the articles of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or of this act. That is how the definition is given. So articles means it is nothing but the articles of association of a company, and it could be either originally framed or altered from time to time in pursuance of a company law. That is what the definition was given under Companies Act. In practical, articles of association of a company contains certain internal rules and regulations of the company. See why all these internal rules and regulations are required in order to manage the company. In order to manage the company, there are certain rules and regulations which are internal. So these are called as articles of association. So dear students, here there are about seven provisions which are given under this particular topic to understand the different provisions of articles. So the first point says that it contains regulations. The articles of a company contains regulations for management of the company. We already discussed that rules and regulations are to manage the company. So it contains certain regulations in order to manage the company. Second point says inclusion of matters, which mean to say that if company is running its business over a period of time, from time to time different rules may be required to be incorporated or included. Some of the rules may be deleted also. So inclusion of rules in the articles of association is provided for under the act. However, here a company may also include such additional matters in its articles as may be considered necessary for its management. So, over a period of time, wherever the company feels it is necessary to include some additional matters that can be included in the articles. That is the second point. The third point is talking about entrenchment. Entrenchment for what? Entrenchment for certain rules or certain regulations. You know that articles of association is consisting of certain rules and regulations. So for some of these rules there will be entrenchment, which means to say some protective shield will be provided for all these rules or regulations in order to make the company more and more sustainable. So usually an articles of association may be altered by passing a special resolution, but entrenchment makes it more difficult to change it. So entrenchment means making something more protective. Normal course of time, a rule or a regulation in the articles can be altered by passing a special resolution. However, entrenchment provision makes it not only the special resolution, it goes beyond the special resolution. So, what does it mean? Beyond the act, it whatever the act provides for the articles rules, beyond that you also can provide some entrenchment to it. So here contain provision for entrenchment. So it is of a more restrictive. It is of a more restrictive. So how these entrenchment provision can be included? So dear student, here the entrenchment for any rule or regulation can be extended at the time of a formation of a company or by an amendment in the articles. By an amendment to the articles also it can be provided. However, when entrenchment is to be provided based on the amendment, for such an amendment to the articles, it should be agreed to by all the members of a company in case of a private company. If it is a public company, to provide a entrenchment to any provision by amendment, it requires a special resolution. So this is the difference. At the time of formation of a company means it is okay, it will go in the normal course of action. But by an amendment means if it is a private company, the consent of all the members is required. If it is a public company, a special resolution shall be passed to give entrenchment to any of the provisions in articles. So, such a amendment or such a entrenchment shall be given effect only by giving a notice to the registrar in the form and manner as may be prescribed. So, dear students, if you see, there is a small flow chart is given here. The time of entrenchment, it can be either at the time of formation or at a later also. If it is at the time of formation, this goes in the normal course of business. At a later means only by means of amendment. By means of amendment. So when it is by amendment, if it is a private company, all the members shall give their consent. If it is a public company, entrenchment can be given to any of the provisions in the articles only by passing a special resolution. Only by passing a special resolution. So this small diagram will make you understand how the entrenchment will be given to any of the provisions in the articles at the time of formation or by an amendment. In case of an amendment, how it can be done in case of a private company and in case of a public company is given very clearly in a simple way to understand. So here I want to explain an example which is given in our course material to appreciate better the entrenchment provision, how it is being kept in the articles of association. See, Mr. Tarun promoted an education startup and got it registered as a private limited company. Initially, he and his wife are holding all the shares in the company. In the articles of association of the company, it is written that Mr. Tarun will remain director of the company for lifetime. But he has a fear that tomorrow, if 75% or more shares of the company are held by non-family members, then by passing a special resolution, articles may be changed and he may be removed from the post of director. So therefore, it was also written in the articles that he can be removed from the post of director only if 95% votes are cast in favor of the resolution. This is an entrenchment. Dear student, you understand that. So to alter the articles, what is required is special resolution is enough. For a special resolution, so 3/4 majority is enough, which means to say 75% of the votes are in favor of the resolution, then that resolution is considered to be passed, thereby articles can be amended. So here Mr. Thorne is afraid of that he may not continue as a lifetime member if the members from other than out of his family holds say more than 75%. At any time he may be thrown out as a director of the company. So that is why he wanted to provide an entrenchment for passing a special resolution, only with respect to his continuation as a director of that company. What is that entrenchment? 95% of the votes are required for passing a resolution with respect to discontinue him as a director. So this a special provision which is a little more protective than what is being provided for under the Companies Act. So that is why it is called as a protective provision, and which is an entrenchment. So the next point is that forms of articles. You already know that the Schedule 1 will have a model of articles and as well as the memorandum from A to E. The first five tables gives about the memorandum, and from F to J are the model tables for articles. So what the point here says is that so the company can have its own articles. It need not be of the table F to J. It may have. And however, the fifth point says that model articles, a company may adopt all or any of the regulations contained in the model articles applicable to such company, which mean to say that some of the articles are applicable for a private company and some one is for the a public company, and some other model articles are applicable for a public company with guarantee, some for a public company with capital. So like that. So whatever is applicable can be adopted if company wants it. So the sixth point is talking about a company registered after commencement of this act. In case of any company which is registered after the commencement of this act, insofar as the registered articles of such company do not exclude or modify the regulations contained in the model articles applicable to such company, those regulations, so far as applicable, be regulations of that company in the same manner and to the extent as if they were contained in the duly registered articles of the company. So it says very clearly, company registered after the commencement of this act, how these articles and model articles will have impact on it is being given under this point. And the last point says that section not apply on company registered under previous company law, which mean to say that nothing in this section shall apply to the articles of a company registered under any previous company law, which mean to say that the earlier Companies Act 1956, unless amended under this act. If unless these articles are amended under the Companies Act 2013, nothing about these articles of association given under Act 2013 will be applicable to the articles which were there under Act 1956. That is the point you need to understand. These are the only 7 points which are talking about the various provisions of articles of association. Dear students, a question may likely to be asked about defining the articles of association and a brief discussion about the provisions of which deals with the articles of association. In all such cases, you need to write about all these 7 points, wherein you have to focus more on entrenchment provision, how it is provided. If the examiner desires, sometimes he may ask you a question exclusively on entrenchment provision. What is meant by an entrenchment provision and how it can be included, and what are the guiding law provisions with respect to a public company and a private company. These things also may likely asked as a separate question if examiner desires so. This is all about that. And the next topic that I would like to discuss with you, which is very, very important, that is the legal provisions regarding doctrine of indoor management. This topic and this question is very, very important for your examination point of view. The doctrine of indoor management is like that of a doctrine of ultraviolence that we discussed in the previous session, is very significant with respect to the protection that will be given to an outsider. So doctrine of ultraviolence protects the company from outsiders, whereas the doctrine of indoor management gives protection to the outsiders who is dealing with the company. See, what it says is that according to these doctrines, persons dealing with the company cannot be assumed to have knowledge of internal problems of the company. See, which mean to say that when a person who is dealing with the company or entering into a contract with the company, he can have a right to presume that whatever is to happen within the company as an internal proceedings or the internal matters, he can presume that it is been happening normally. He can simply assume that all the required things were get done properly in the company. He can presume that. So stakeholders need not inquire whether the necessary meeting was convened and held properly or whether the necessary resolution was passed properly. They all are entitled to take it for granted. They can consider that internal matters went on very well, that the company had gone through all these proceedings in a regular manner. Whatever is to happen within the company in regular manner, like conducting of meetings and passing of the resolutions and obtaining the necessary majority for the resolution and filing of that resolutions with the register of companies, etc., etc. When a person who is coming in contact with the company, he can presume and assume that all these things were went off well, and he can take it for granted also. This doctrine helps protect external members. See, dear students, you should understand this doctrine helps to protect external members from the company, states that the people are entitled to presume that internal proceedings as per document submitted with the register of companies. So, internal proceedings are being happening as per the documents submitted with the register of companies. The doctrine of indoor management, in fact, was evolved 115 years ago. 150 years ago, this doctrine was evolved. The role of doctrine of management is opposite to the role of doctrine of constructive notice. Dear students, this is the point every one of you should understand and you should not get confused. This is a very simple topic. The doctrine of indoor management is quite opposite to the role of a doctrine of constructive notice. Now you need to understand the tiny difference between the doctrine of indoor management and to that of a doctrine of constructive notice. What is the doctrine of constructive notice? Doctrine of constructive notice means whatever is available in the public office, that is the ROC. With the ROC, all are the public documents. So the persons whoever is coming in contract with a company are presumed by the company that they have knowledge of all the records available with the ROC because they are the public documents. So which mean to say that a company can presume that the person entering into the contract have the knowledge of public documents, which says that it is a doctrine of constructive notice. Doctrine of constructive notice protects the company from the outsiders. The doctrine of indoor management protects the outsiders from the company. This small, beautiful difference everyone should understand. Then only you will be able to give a correct answer. See here, the doctrine of constructive notice protects the company against the outsiders. When it comes to the doctrine of indoor management protects outsiders against actions of the company. This doctrine also is a possible safeguard against the possibility of abusing the doctrine of constructive notice. So, the doctrine of constructive notice will protect the company. So, the protection given to the company should not be abused. So, that is why the doctrine of indoor management has come into effect. So, there are certain basis for the doctrine of indoor management. My dear students, you have to understand what is the basis. There are about two bases for us, and first basis says that what happens internal to company is not a matter of public knowledge. What is happening inside the company will not be known to the outsider. An outsider can only presume the intentions of the company but not know the information he is not privy to. That is the first basis. Second, if not for the doctrine, the company could escape creditors by denying the authority of official to act on its behalf. See here, if the doctrine is not available, the company could escape creditors by denying the person who is acting as an official did not act on behalf of the company. By saying so, the company can deny the liability. But the doctrine of indoor management is protecting the outsider, thereby the company cannot deny the authority of official to act on its behalf. So that is why this is the protection given to the outsider. Under the doctrine of constructive notice, the company cannot abuse its power to deny the liability to an outsider. So there are certain exceptions. So the exception to the doctrine of indoor management. So in case of all these exceptions, if it is proved the doctrine of indoor management is not going to provide any safeguard to an outsider. One is that knowledge of irregularity, which mean to say if something inside is not happening properly, if it is known to the outsider who is coming in contract with the company, in such a case, if something happens to the outsider, he cannot get any protection because he know that the internal management problems are there. So when knowing that there are problems in the internal management, you cannot take that as a granted. Hence, in case of an outsider has actual knowledge of the irregularity within the company, the benefit under the rule of indoor management would no longer be available. That is the first exemption. So this exception you have to keep in mind. Second exception is in case of negligence. Negligence by whom? Negligence by the party who is coming in contract with company. If the minimum effort, the irregularities within a company could be discovered, the benefit of the rule of indoor management would not apply. The protection of rule is also not available where the circumstances company does not make a proper inquiry. If the third party entering into a contract with the company does not make a proper inquiry of an ordinary prudence, in all such cases it is considered as a negligence by the other party. So in such a case, the protection under the doctrine of indoor management cannot be extended to the third party. And the third exception is that forgery. The rule does not apply where a person relies upon a document that turns out to be forged, since nothing can validate forgery. See, understand. A company can never be held bound for forgeries committed by its officers. Forgery here means if one of the officers of the company forged the documents of the company and entered into a contract with the third party, in such a case, the third party cannot take a protection under the doctrine of indoor management because the validation of a forged document is not possible and it is a void ab initio. Hence, under these three exceptions, the doctrine of indoor management cannot protect the third parties. So, my dear students, you have to remember these are the three areas where the protection will not be given to a third party under doctrine of indoor management.